Hello and welcome to the Estate Planning Toolbox. Thanks for taking some time out of your day to check out everything we have going on here. My name is John Connor and I am an attorney in the Trust and Estates Group of Graves, Doherty, Heron & Moody, a law firm located in downtown Austin, Texas. This podcast is a client-focused podcast covering various estate planning topics, including wills and trusts, powers of attorney, corporate entities such as LLCs and limited partnerships, probate administration, and everything in between. Thanks very much for stopping by. Hello everyone and welcome back to the Estate Planning Toolbox. Today we're going to be continuing our discussion of estate planning with mineral interest and are going to be talking about some structures for managing and transferring your mineral interests. Before we do that though, let's take a look at today's movie quote of the day. And today's movie quote of the day is, "I feel the need for speed." I feel like that's a pretty easy one, pretty famous one, so no hints today. And if you don't know what movie it's from, I'm not going to be mad. I'm really just going to be disappointed. But of course, if you don't know what movie it's from, stick around until the end of the podcast and I will tell you exactly what movie that is from. So today we're going to be discussing some different structures used in managing mineral interests. We'll go through a couple of different trusts, revocable and irrevocable trusts, and talk about a couple of entities, notably the limited liability company or LLC and the family limited partnership or FLP. And for both the trust and the entities, we'll actually take a quick look at how those would work for holding and managing your mineral interests. So first, let's take a look at revocable trusts. And as their name indicates, they are revocable, meaning that you can set them up easily and then fairly easily revoke them and take all the assets back. And generally, how these are going to work is someone is going to set up the trust, most likely name themselves as the initial beneficiary and as the initial trustee, and then they can transfer assets to that trust and then manage those assets as the trustee. They can then make distributions to themselves and generally speaking still use those assets for their own benefit. Revocable trust can be very useful from an incapacity or disability planning standpoint in that usually when someone sets up a trust, they will not only name a primary trustee, but then also one or two backup or successor trustees. So if someone has named themselves as trustee of a revocable trust and they're also the beneficiary and then they suddenly become incapacitated, one of those successor trustees could then step in and continue managing the assets of the trust and continue making the assets in the trust available for that now incapacitated beneficiary's benefit. Revocable trusts do provide for probate avoidance because the assets in a revocable trust are not part of a person's estate for probate purposes, meaning any asset in that trust doesn't pass under a person's will. Now, as I've mentioned in previous podcasts, avoiding probate is not such a big deal in Texas because we have independent administration, which helps keep costs down, but revocable trusts do provide for probate avoidance. Kind of for that same reason, they provide for additional privacy of assets because during the probate process, if we have an independent administration, we have to file an inventory. But again, the assets of a revocable trust are not part of a person's probate estate, meaning we don't have to list those assets on the inventory, which is public record. So again, revocable trust will provide a certain amount of privacy regarding the assets held in that trust. Now, irrevocable trusts, as their name implies, are irrevocable, meaning that once they're set up, really cannot be revoked without going to a court and asking the court to revoke the trust. So for that reason, it's important to remember that once an asset is transferred to an irrevocable trust, it can be very difficult and costly to get that asset back. So you'll want to consider that before you actually transfer an asset like a mineral interest to an irrevocable trust. Irrevocable trusts do provide many of the same benefits as revocable trust in terms of the disability and or incapacity planning, the probate avoidance, and the privacy of assets, but they do have a few other benefits to be aware of. One of those is creditor protection. Assets held in an irrevocable trust are creditor protected. Revocable trusts provide very little, if any, creditor protection because the assets are revocable, meaning that the person who transferred them into the trust can terminate the trust and get the assets back. So creditors can get an asset in a revocable trust. For an irrevocable trust, the assets cannot be taken back easily, so the creditor cannot get at the assets in an irrevocable trust. For that reason, we wouldn't want to have someone set up an irrevocable trust, name themselves as beneficiary, name themselves as trustee, and transfer assets to the trust because even though it's irrevocable, that really wouldn't provide any creditor protection. But if that person wants to set up a trust for another beneficiary's benefit and make the trust irrevocable, then The assets in that trust will be creditor protected from that beneficiaries and from that transferor's creditors. The assets in an irrevocable trust are also not divisible upon divorce, so irrevocable trusts provide divorce protection. Also, irrevocable trusts can be set up so that the assets inside of them are excluded from a person's gross estate for estate tax purposes. Generally speaking, because we don't want to have someone set up the irrevocable trust and name themselves as beneficiary and trustee, these trusts are most commonly used to pass assets to other beneficiaries and/or a lower generation, such as children or grandchildren. So how are trusts going to work with mineral interest? The way this would work is we would set up the trust, and then we would transfer the mineral interest to the trust. Now it is the trustee who is responsible for managing that mineral interest on behalf of the beneficiaries. That might include entering into leases or receiving royalty payments. But do keep in mind that any payments received on those interests are now going to be received by the trust and become property of the trust. So they're still going to be available for the benefit of the beneficiaries, but they're not going to be transferred to the beneficiaries directly. Instead, the trustee will need to abide by whatever distribution standard is in the trust for making a distribution to the beneficiaries of the trust from the payments received on those mineral interests. So transferring now, let's talk about limited liability companies and family limited partnerships. And here's how these work. First, we have to properly set up the entity, and that's going to include filing a certificate of formation with the Texas Secretary of State. We'll include naming a registered agent. We'll include naming a manager in the case of an LLC or a general partner in the case of an FLP. And we'll need to get an EIN assigned or tax identification number assigned to the entity. Once we've had that entity set up, we can then transfer interest to the entity. That could be cash, it could be other investment assets, or as we'll discuss, it could be mineral interest. Now, once someone has transferred the assets to the entity, it's now the entity that owns that underlying asset, that owns that cash, that owns that investment asset, that owns that mineral interest. And the transferor who transferred the interest to the entity now owns an interest in the entity and doesn't, for creditor purposes, for tax purposes, no longer owns that underlying asset. So some benefits of these entities is, one, it provides a good amount of creditor protection. In the case of LLCs or FLPs, any creditors of the entity will not be able to get at the individual assets of the members and or limited partners. So there's a good amount of creditor protection. Instead, a creditor is really only ever able to get a charging order against the entity, meaning that if there's ever a distribution made from an entity, they'll have rights to that distribution, but they can't force a distribution, they don't have any voting powers, and they never become a member or partner of the entity. These LLCs and FLPs are really good vehicles for asset management because you can organize the assets, you put them all inside this entity, and then it's the manager and or the general partner who becomes responsible for investing those assets. So if cash comes in, they can invest that cash, they can buy new assets, they can sell assets, they can make distributions out to their members or partners. So it can be a really good vehicle for managing a family's assets, including their mineral interest. And as we're going to discuss, in terms of mineral interest, it's a great way to keep the mineral interest intact, because very often when someone has a mineral interest, it's already a fairly small interest, and then that interest will only get fractured more whenever it passes on to new beneficiaries. But LLCs and FLPs can keep that interest intact, and instead what a beneficiary would get would be a membership interest or a partnership interest, so nothing would change in regards to that underlying mineral interest. Do keep in mind, from a tax perspective with both of these entities, that they are what are called flow-through entities. So any income that is generated by an asset in an LLC or FLP is actually going to be reportable on the individual tax returns for the members or partners. Now, with that said, obviously, the manager or general partner could make a distribution from the assets of the entity out to its members or partners to cover that income tax liability, but just keep in mind that any income generated by either an LLC or an FLP will be reportable on the personal income tax return of its members or partners. So how are LLCs and FLPs going to work with mineral interest? Well, after we've properly set up that entity, we would transfer the interest to the entity, and the transferor would take back the interest in the entity. As a part of that, we would do a deed to the entity, and then, if necessary, we would have new division orders issued in the name of the entity. Now, that interest, that mineral interest, is going to be managed by the manager and or general partner. Maybe they'll enter into new leases or just simply manage the interest and receive payments, royalty payments, lease payments, and then invest the cash from those payments. Again, because it's the entity that owns that underlying mineral interest, any payments received on that interest are going to be made to the entity and not directly to the members or partners, but the manager or general partner could decide to make distributions of cash out to its members or partners. Upon the death of a member, instead of receiving a further fractured mineral interest, what the beneficiaries are going to receive is a membership interest in an LLC or a partnership interest in an FLP. And the benefit here is we don't have to do any new deeds, we don't have to do any new division orders, so nothing changes in regards to the underlying mineral interest. Any payments that are made are going to continue to be made, and all we really need to do is some small paperwork to have a new member or partner admitted to the LLC or FLP. So as you can see, these LLCs and FLPs can be great vehicles in terms of managing your mineral interest and also transferring your mineral interest to your desired beneficiaries. So that's really going to do it for today. Next week, we'll conclude our discussion of estate planning with mineral interest and actually talk about the probate process and how it applies to mineral interest. Now, before we go, here is the answer to today's movie quote of the day. And today's movie quote of the day came from Top Gun.
I feel the need for speed.
Well, thank y'all again for stopping by. Here again is my contact information. If you have any questions or topics you'd like to see discussed on the Estate Planning Toolbox, please do not hesitate to give me a call or shoot me an email. Thank y'all again for stopping by, and be sure to check back in again soon for the next episode of the Estate Planning Toolbox.